I was trying to say it quietly. If you get 50% of any community, aren't you disenfranchising the other 50%?
50%.
So the answer to that, Councilman, is that's why we're doing this. Well, just as if you're only getting your signatures from one half of the precincts, yes, there's another half that didn't have a say in this petition and will only have their say if it's successful in going to the ballot. The intent of this right now is you don't even need 50% now. This is like a modest step. Right now you could get, you only need 20% from wherever you get them in your ward or the city.
So you can get 20% from one precinct now?
Yes. This
Okay.
is an attempt to at least make sure that at least 50% of the precincts are represented in this, this significant action of the voters.
Okay,
So
what I'm saying is, how about the other 50%?
I believe that it would be very challenging and almost, you don't want to be too, onerous as well in
Right.
terms of like requiring, because, you think about just practically, we all, or not all of us, but many of us have gone and done signature drives and petitions and all, and it's hard to get, there's certain precincts that are very low voting. I think that it would be, it would run the risk of making it too onerous to make it 100% of precincts. But I'd be, the reason I suggested 50 is that's just what the state requires. And it seems that from the state, it seems reasonable that you can't get all of your signatures from Cuyahoga or Mahoning. You have to get at least half the state to buy in. Here, we have to have at least half the precincts to buy in just to get the petition filed. Those other 50%, is it fair to them that their judgment is being questioned? Maybe not, but they'll have a chance to reaffirm their vote, yea or nay, if that does go to the ballot, does go to an election.
I understand. The only other question I have, Mr. Chairman, doing a recall petition. Let me say, for example, you got 5,000 votes in the election, and the people that voted in that election, 20% of those people can actually say these 5,000 votes don't count. 20% of those people can say, no, he should not be in office. And those 5,000 votes are meaningless, is what it's saying. That's why I suggested the 100% instead of the 50%. But I can live with 50%.
And
You know,
I
that-
would leave it up to the commission. I'm not opposed. What I'm hope that we're doing is striking a balance between the right of citizens to petition and the right of those that have already spoken and voted. My personal opinion not that it matters, is that, recalls have never been successful. They take a tremendous amount of resources. But in the event that there is an elected official that maybe has been involved in some criminal or something that does rise to the level, then yes, we do need a process. Unfortunately, the recall initiatives or efforts that I am aware of since the time I've been here, they've been just straight politics. It hasn't been based on a crime, or it hasn't been based on something else. It's been straight wanting a second bite at the apple. And that's people's right, but I just think if you're going to file a petition second guessing what the voters decided in a fair and free election, then it needs to be at least a little bit more representative than how it is currently written.
Great, thank you. Tom?
Mr. Chairman, I'd just like to say I think this is really thoughtful, and I really like the way that it is constituted. I think part of what elected officials have to deal with on almost a daily basis is making decisions on things that some people are going to like and some people are not. And, this kind of eliminates that situation where you might support something that a handful of people right around that thing you supported don't like, where many other people in your ward may actually like. And while I think that the power to recall is very important for the citizens, I also look at places like East Cleveland, where people spend more time recalling than they do governing, which is not very good for anyone. And I think this strikes a really good balance between, allowing people to have that voice, but making sure that it is representative of the entirety of a community, not just one small group of people who may not like what you're doing.
Thank you. Yes, Tom. Carrie, Councilman.
Thank you, Mr. Chair. And I would just echo Tom's comments. And I voted against increasing from 20 to 30% in the last round. What I will say, though, is that and then I agree with the council president as well, there has to be a mechanism. But to not downplay the fact that, folks hire you for a 4-year, or whatever the term is. For council, for example, they hire you for a 4-year term and come out and they expect that 4 years and they vote with understanding the fact that you're going to have a 4-year term. So I think that if a recall is to come about, there should be a mechanism. I agree keeping it at 20%, but similar to what Tom said, ensuring that the step to decertify, essentially, the votes from the last general election should be one that's somewhat representative of a broader array of people. I think that makes sense.
Very good.
Mr. Chairman.
Yes, Councilman.
The guy sitting next to you, where do you live?
Tom.
I live in your ward, Councilman.
Sort of criminal behavior.
He knew that because he knows the answer to every question he ever asked.
Just a lightweight joke, I know him very well. Mr. Chairman, the 50% is reasonable. And what we are actually doing is just following state law. Is that correct, or?
Yeah. I mean, it's a similar process. It's not state law that you have to do this to recall someone, but it's state law for an initiative petition to change the Ohio Constitution needs to be reflective of at least 50% of the counties.
My only other question, Mr. Chairman, is the recall petition itself, the circulator of the recall petition. Are we going to get to that, or is that part of this, or?
We did that
Somewhere in there.
that was part B, but if you wanted to revisit it, this
Well,
is an
I was-
open discussion, but how, can we
Since
just?
it came up, Mr. Chairman, since it came up that you
Yeah.
got to get 50%, 20% for 50% of the ward or the city, it would only stand to reason that we would look at the circulator of those petitions. Do they have to live in the ward? Do they have to live in those 50% precincts?
I know, and we tried to go down that path with the paid circulator versus the resident circulator. It's really hard to codify. Yeah, I don't know the answer to that. But it would be appropriate, but I think if we could wrap up the discussion on the 50% of the 10% of the 20% while everybody has a reasonable understanding of it, then we can move to your circulator. What? He's making fun of me? It's fine if you are. But any further, I'm not dismissing it. I just want to come back to it after we close the discussion on this and have anybody, did you ever?
Yeah, I know the Board of Elections isn't here today, but I would just be curious if this is a common practice in any other city. I don't remember hearing of this, but
Yeah,
that might be a good question.
I know it
for
came
the
up
Board of Elections. I'm just not sure
on
why
our,
Cleveland would be
So Friday
step-
we
drastic
met
step
with,
different from the rest.
on Friday we met with the Board of, I had to chair a committee meeting at NOACA. I did not attend, but staff was there. Was this proposal discussed at the Board of Elections on Friday?
No,
It was not.
it was not.
Okay.
No.
Are you or is anybody familiar with other municipalities' requirements for recall being reflective of any percentage of a jurisdiction?
I am not.
Okay.
Mr. Chair, I am not. I didn't specifically look for that, but I would say that every community's recall process is fairly unique
Right.
to that community. So, but in answer to the question, I don't know that there's another municipality that has something like this. They might not be as insightful and creative as Cleveland is.
Nice.
If there's an interest, we can take a look for next time, just to kind of cover other municipalities, what they may or may not do for recall.
It's certainly a fair question. And I would kind of agree that everybody does their own thing, and once we go down, then we can come up with a bunch of, if the commission, or if nobody has an objection to at least calling the roll on this and doing further research for future discussions, my hope is to clean up parts A and B, just the proposals that were put on the table today, and start calling rolls on things in order to get clarity. But if somebody's not comfortable, then I would just vote against it. Yep.
Are we there too? Are we dealing with the next paragraph as well?
There's only one.
I only see, in section 17,
Yeah,
I only see
Well-
one paragraph.
the changes there, the signatures must be obtained from at least one half of the precincts of the city or ward petitioning for recall. Okay. From those precincts, there must be signatures equal to 10% of the total vote cast in the city or ward respectively at the last precinct. What does that mean?
So the numbers.
Yes, Council President, please.
It means just that. So if 20% of, it's 20% requirement of those who voted in the last regular election to meet the threshold. This is 10% of that 20. So it's of those that were electors in the last mayoral election, municipal election, 10% of them have to sign to count as your one half of the precincts. Yes.
Good. Thank you,
All right,
Councilwoman.
I just wanted to clarify. Thank you.
Further discussion on proposal to amend section 17. Hearing none, I'll ask to call the question now. Yes.
Yep.
Yes.
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 Thank you. Where am I? I just got confused. Okay. Amend section 23, Rachel, is that where we are? Okay. New proposal, Part B, elections, proposal amend section 23 to add that recall petitions cannot be filed against the mayor or a member of council after taking office within 12-month period prior to the next regular municipal election. Rachel, didn't we just
do this. This one's freezing.
we already did this.
No, this is
Oh.
different. This is a different proposal. We did change the 3 to 12 months, the 3 months to 12 months.
Correct.
There's another limitation that is being
In the
proposed.
charter, right.
And that is that you cannot submit a recall petition within 12 months prior to the next regular municipal election. In other words, the final year of the term, you cannot submit a recall petition.
So in proposal number 8 that we already voted on and approved,
Yes.
where it amended section 23 to extend the time period during which recall petitions cannot be filed against the mayor or a member of council after taking office from 3 months to 12 months and after a recall election from 6 months to 12 months. That did not address the last 12 months of a duly elected representative,
That's correct.
which is why we are now considering
Another proposal.
another proposal on section 23 to add that recall petitions cannot be filed against the mayor or a member of council after taking office within the 12-month period prior to the next regular municipal election. Thank you.
So-
Yes,
So
Justin.
one concern I have with this piece of this proposal is if there's an egregious act done by that public official, I believe the voters should still have some kind of process to remove that person from office, even though there's a next election coming up. So that's my main concern in regards to not having some type of process to remove an elected official if there is some egregious acts going on as they're in that office.
Okay.
Mr. Chair? if I
Yes.
may. With this proposal, I believe there's only now a 2-year period that someone could be recalled. We've also made it harder to even recall because it seems like it's now an extremely difficult process if we were to follow this language where you only have 2 years.
Right.
We've made it harder to recall. I think at some point we need, I understand the disturbance that it causes, that we need to have, elected officials deserve to do their job, but we've made it an extremely difficult process at this point. We're making it even harder in the age of social media where information is now more available, where scandals come out even faster. I don't think we want to make it even harder to require citizens to have to live with someone they don't want.
Mr. Chairman,
Yes, Pastor.
I think just correct me if I'm wrong, is the intention of this proposal, since there's already going to be an election coming up,
Yes.
there's no reason to spend money on a recall? And if that's the intention, I definitely agree with that. There's no reason, what's 12 months going to do? It takes you 12 months to campaign. So
Well.
if you're going to do it right.
And that was part of the discussion too,
Yeah.
is if I'm gearing up to run against somebody, shoot, I'll just start my campaign 12 months earlier on a recall, waste everybody's time and energy, and then run
And
against
money.
him or her come
Right.
January.
I understand. Is that a common, I mean, have we had that issue repeatedly? It just seems like we are making it very difficult to recall at this point. There's a 2-year period you get
Right.
to recall, and we've made the petition process harder. So at a certain point, I think we need to there needs to be balance.
Right.
Well, let me just finish my comment.
Oh, I'm sorry, yes.
I think it ought to be extremely hard to recall a person. What it takes to get elected, it should take the harder we make it to recall a person, that the process is fair. I think that's very important because getting elected, I would never run for office. I support people running for office. That is a very difficult task to just run for office. And one of the reasons why people don't like running, we have a lot of qualified, great people who don't run for office because of the process is already tough. It should be even tougher for a recall. Once that person takes the grind of an election, we should give that person an opportunity, and the voters who will, as much as I wish we could recall the president right now. I want to recall him, but we can't because those voters spoke.
Right. Thank you, Pastor Phillips. Councilman Casey and then
No,
Justin.
you have to elect Congress to
Thank you,
impeach
Mr.
him.
Chairman. Our council terms are only 4 years long, right? So we're still giving you the opportunity, not you guys specifically, but we're still giving the voters the opportunity for half of the term to still recall somebody. So once you're elected, you've got the first year to recall, or you don't have the first year, you don't have the last year, but you still have more than half of the term to be able to recall somebody. So I don't really, I mean, I like this proposal just because if somebody's going to be recalled within the 12 months, there's already, as as Councilman McCormick has said, there's a recall on every council person every 4 years anyways, right? So I think giving them half of the 4-year term to be able to be recalled is acceptable.
Thank you, Councilman. Justin and then
Chairman?
Councilman. Yes.
I was just, Mr. Chairman, I would just echo and agree with Reverend Phillips on the comment of it should be difficult to recall elected officials. I just want to make sure the voters have a process to remove somebody from office if there's egregious acts going on there. And the charter is supposed to be that balance. And so I want to make sure that balance is in place in our governing document. So that's really my main concern.
Great. Thank you. Councilman McCormick.
Thank you, Mr. Chair. And this is just for information for the table. Beyond a regular election, so for example, for council as an example, every 4 years, and beyond a recall, if someone commits a atrocious act, is there another mechanism to remove an elected official in the city of Cleveland beyond recall and beyond your every 4 years?
No.
Support.
Would adjudicate in a 12-month period. If you're convicted of a felony, you can't hold office. But
Right.
that probably would result in 12 months.
So in order to leave office, you have to, remove yourself, whether through death, stepping down, whatever it might be, resignation. You can be recalled, and obviously the regular election cycle. Is that accurate? Okay, just,
We tried and he couldn't. No. Councilwoman Brady and then Councilman Johnson.
Mr. Chairman, I forget what year, I want to say it was 83, I'm not sure, but around there, when we went from 2 to 4 year terms, the 2-year terms were atrocious because people were campaigning against you for the entire 2 years. Now, there's a number of us that serve on council right now that know how long it takes to do anything in your ward. I mean, to dig a hole could take you 2 years to get through the bureaucracy. So I just wanted to, we have changed to 4 years because there was a recognition that everybody was running for office the entire time they were in office for 2 years. And people were running against them. Huh?
No, sorry, continue.
So, I think that this is very fair. You have 2 years to recall someone if they're not doing, if you're not satisfied, if you're not doing what you're supposed to do. Mainly, if someone does something egregious, and I don't know that that is specified anywhere. I don't think it is specified that you have to have cause, because I actually do think that that you should have to have cause to recall someone beyond the felony, which would be an automatic, you can't serve anymore. But, I don't believe it's in the charter, but it is in the charter. Are we going to get to that?
You have to state
But
reasons.
any reason.
You have to
though.
state reason, but it's any reason. It doesn't
But that's the same
say that
thing
you
with- for
were
cause. What's the cause?
shoplifting or stole a car
No, you
or,
can't.
something like that. Or is that grand theft? Is that a felony? I'm not sure.
Just don't do it, Councilwoman.
Just don't do it. Just don't shoot anybody.
That's for sure.
But, no, I mean, we need to address, I think, cause for recalls, because we can't just have them just because a group of
Yeah.
people are disgruntled.
That's the process we live in, and I don't agree that we have to, because once you start listing causes and, it's a real slippery slope that I mean, if there's a reason, but they just need to state it, and if we face recall or if somebody faces recall, that's just life. I'm not gonna sit here and try to define
Figure out what
what's
cause
good and
is.
bad from an
Okay.
elected official and what grounds could be pertinent to a recall. I think that's chasing our tail. Me personally, though, I mean, you're a commission member just like,
Well, if we're getting to that,
Mr. Chairman?
I had Councilman Johnson and then
Absolutely.
Tom, and I'm,
Oh, you can go.
all right.
I'm curious, what is roughly the timeline of a recall process? Like, from the time somebody decides they want to do it and begins, or I guess I should say, from the time somebody's collected the signatures that are necessary, because they can do that on their own time.
Rachel
and
is
hands it
our
in.
expert.
Yeah, it's actually in the charter.
Okay.
But you have 5 days, the person the person to be recalled has 5 days to resign. If he doesn't, then an election has to be held within 40 to 60 days. And it can't be any more than 60 days. So, I mean, so that's basically it. So you do, practically speaking, you run into, the closer you get to the next regular municipal election, you run into overlapping. That's another reason why that last year is so difficult to have, a recall. Because you're recalling the person in the term that they are in. If he's going to be running again in 3 months, then the recall doesn't matter.
Yeah. And that's where I understand and agree with Justin's point. It's like, it's one thing to say, because I agree with the 12-month rule from a political standpoint, right? Now, if somebody does something that is egregious, how do you define that? I also understand why you would want to have that process. But if the process is going to take 3 to 6 months to go through anyway, till you actually have that election, now you're talking about actually just using a lot of taxpayer dollars to save a few months, wherein undoubtedly within the 12 months, I think people will start campaigning against that individual anyway,
Right.
based on what it is that they have done. Because that's the other part of recalls. It's like, on the one hand, it's like, I think it's important to talk about that citizens have the right to do it. On the other hand, you're also using a lot of taxpayer dollars to fund one of those things to move it forward. I don't know, it's interesting, but I don't know. I think it's a conundrum, because I understand what you're saying.
It is.
Right.
But like recalling within a 12 months of an election also seems kind of crazy, just in terms of the amount of time that goes into it in dollars.
Thanks, Tom. Councilman Johnson?
Mr. Chairman, the clarification of a recall election that takes place, the cost, it used to be $500,000 to $600,000 for a recall election. Now, is that still the case, or does the city have to pay that, or does the Board of Elections pay? Who pays it?
The city of
The city
Cleveland pays
pays
for elections.
The city pays for recall election.
Yes.
And that cost is still $500,000 to $600,000?
Well, if it's a ward, it depends on if it's a ward-wide or citywide,
Right.
the number of precincts, but I think they gave us a number at some point. I don't remember what it is, but it's costly.
Okay.
It's hundreds.
Right. So the proposal currently on the table is about the 12 months prior to an election. Recall petitions cannot be filed against the mayor or a member of council after taking office within the 12-month period prior to the next regular municipal election. Further discussion on proposal to amend Section 23 again.
Just answer Councilman Johnson's question. I wrote it down when the Board of Elections here. It's $2,300 per precinct.
Right.
Yeah.
Thank
So
you.
it's.
Good note-taking. And most wards, as you know, have how many precincts?
Between 20 and 25.
Right. So it gets up there pretty quick. I would ask that we call the question. Alan? Yes.
No.
Yes.
No.
Yes.
No.
Yes.
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 Thank you, everybody. Next proposal. Is that part C? Yeah. So we're actually on today's agenda?
We are.
All right, everybody. Hour and a half in. Thank you. This is hopefully an easy one to amend Section 28 to provide that if the first Monday is January is a legal holiday, the first meeting of a new term shall be held on the next business day.
There have actually been the first council meetings on January 1st.
Sure.
Yeah, was this?
In 1992.
Yes. So, questions, comments, concerns? Call the question. Yes.
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 Oh, yes.
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 Thank you, everybody. New proposal, Part C, Chapter 5, Section, proposal to amend Section 28 to allow for executive sessions as provided for in state law.
Right.
Rachel?
Yes, so
Thank you.
as I'm sure you all know, all official actions and deliberations of a public body have to be in open meetings. The exception is in the case of permissible executive sessions. Charter municipalities, however, determine by charter how their public meetings are held. We determine in Section 28 that all of our meetings must be open to the public. This amendment would allow for executive sessions to happen only in limited circumstances, and those are all based on state law. Executive sessions under the state law can only executive sessions are a conference between members of the public body, but that exclude the public. You can only adjourn into executive session from an open meeting, and you can only discuss certain limited matters. And I think, Alan, did you just pass out that one? So the one sheet handout goes through what those matters that can be discussed are. Certain personnel matters, purchases or sale of property, pending or imminent court action, collective bargaining matters, matters required to be kept confidential under like federal or state law, security matters, hospital trade secrets, confidential business information of an applicant for economic development assistance, and Veterans Service Commission applications. Those are the only matters that can be the subject of an executive session. And once that executive session is over, you cannot do any deliberations, you cannot vote on any matters in an executive session, and you have to go back and adjourn to a public meeting after the executive session is done.
Thank you.
Yeah, yes, pretty much, yeah.
Close.
I mean,
It doesn't,
it's close,
it
but
doesn't,
the limited matters are verbatim. What? Yes.
oh, right.
Those
Miss-
are listed in state law. Yeah.
Okay, now, if something else comes up, and we as a charter city include that in our charter,
No.
so why are we doing this?
Well,
Because the charter currently precludes us from
Right.
doing any of it.
right. Because
Because
we
we're a
are a
chartered city.
chartered city, and we say in our charter that all our meetings are open to the public. We are not allowed to have executive sessions unless we specify that in our charter.
What we're actually doing is creating in our charter a provision where we can have executive sessions.
That's correct, for the reasons listed in state law.
Can only have the reasons that are out of state law.
Yes.
And if we wanted anything else, that's not permissible.
It would be in
I don't
conflict with
believe
state
so, yeah,
law.
it'd be in conflict with state
and
law.
Could easily be challenged, but we don't know what that challenge, right.
Mr. Chairman, I'd love to hear from our colleagues who are on council to kind of give us some perspective on some issues that you may have wanted to discuss under executive session, but cannot due to the existing law, just to kind of give us some context. And maybe we can hold this for another meeting, because it might require some more discussion.
It's, it's just something that, I don't think about a lot because I don't live in a world where I can have these kind of meetings, right? Anything that is delicate or, or it sits on the list, we don't meet about it. You don't have a meeting about it. We don't talk about it with a quorum. There's some individual council members that are a personnel issue, then you have to do it individually with one person, right? So you have to be cognizant of quorums, you have to be cognizant of the topics that you're discussing, and the audience that you have. But I haven't come up with anything in my 10 years that I thought, man, I could really use executive session right now.
Okay.
I haven't. Council President is if you could.
Again, this comes up very infrequently. However, when there is, an issue of personnel that requires some sort of council action, it's basically, kind of protection for that person who is, that the personnel issue affects. But again, it comes up infrequently, but, when it does, it's sort of important. But it's always, you always run the risk of this one, of doing anything that's not like, ultra transparent, like, immediately people, kind of dig in against it. But, I think if we look at the specified exceptions and the infrequency that these come up, I think it's reasonable. Does it stop city government? Is it something that we can't function without? No. But when that issue comes up every 8 years or every 5 years, it would be good to have. But again, it's just that. It really just comes to like personnel and a few other discrete issues.
Yes, Council.
Thank you. And to Justin's question, I would just say, so I'm opposed to this measure, and the reason is because right now, and let me put this into the modern day, I've got a great deal of trust for our council president, our leadership, our committee chairs, but this would be a charter amendment that would go into the future. And I don't think that we should allow for the council to meet in executive session on any of these matters. Right now, under our current leadership, I don't think we'd have any problem with it. But again, we don't know what the body will look like in 10, 20 years, and so that would be my concern, so.
Right, and once it's in, it's more than likely in.
And to just piggyback off of that, is Councilman Keene's already said, is that there's ways for them to have those discussions, just not in executive session.
Yeah, I mean, but not as a public body, right? So it leaves, if there were a specific issue, the council president, as the elected leader of the body, would probably have to meet with the law director and make a decision. Like, we couldn't discuss and we couldn't, what word am I looking for? The council president couldn't go to each individual member of council and say, hey, listen, I gotta fire so-and-so, right? Then you're violating the Sunshine Law, because you're going to each member of council to get their input. He has to make the decision, or she, whoever it is at that time. Am I right?
That's right.
Because, yeah, there are ways to do it, but it usually just means you better have a good chairman. They better make good decisions, because we haven't, or we didn't want to. We do, yeah. Which we
Yeah.
we didn't want to make it a public hearing, right? It's a tough one, and it's one of those that comes up every time we look at the charter. And again, in my world personally, just as one councilman of 17, I have not ever thought, boy, I wish I could have sat in a room with my colleagues and hashed this out without the media or the public here.
Well, Mr. Chairman,
Yes.
I guess my question, and I think Mr. Bibb is leaning to this, who's proposing this? Because
Well, this
I
came
love
up-
our council president, and I'm very satisfied with him. So I'm wondering who's proposing this? If y'all not proposing it, why are we doing this?
Yeah, this actually came up at our first meeting.
Yep.
Well, it came up 10 years ago, but at our first meeting with Mr. Horvath from
I
the law
remember that.
department, right? He said, listen, be consistent with state law. There's some things that need to be talked about that, don't need to be on Channel 20. And I know it was a really big topic 10 years ago that I don't remember the background to it. There were no specific instances that I think led the discussion, but that's why it's here today, is because, yes, it's been talked about. Yes, it's in our charter that we
Well,
can't
I'm
do
sorry,
it.
let me ask a better question. Are the city council members want to do this? Do y'all want to do this?
Well, I think that's why we're going to call the vote.
Can I,
Just put it, Councilman.
Okay.
may I? Mr. Chairman, the state legislature has executive sessions. The county council has executive sessions. And, many times we're at the table and we're asking questions of a department head, and they will say to us, we can't discuss this because, we're on public television and we have, some issues, pertaining to privacy, but that the council would like to be aware of, because we ultimately are going to have to vote on whatever this privacy thing is that they're talking about. The other thing that's listed here that does make me interested in this is security matters. We do not want to be on Channel 20 talking about security matters. What are we going to do, what are we going to do in Homeland Security? Do we want everybody all over the world to know what we're doing to protect, our residents, our businesses, our buildings, us? So, that's one of the things that, that's an issue to me. But even moreover, as I said, I can't tell you how many times in the last 19 years I've sat here and asked a question. We can't tell you because, we have pending, we have pending lawsuits, or we have privacy issues that we that prevent us from, broadcasting this out to the general public. I mean, I can live with it either way. I'm just pointing out that, there are other bodies that do convene executive sessions even in the middle of some of their meetings to discuss something that, they can't discuss in public. They're just not permitted to. And if we have a need to know something and we're not permitted to do it because we are, in a public setting, it could be a problem. So that's just my comment.
Thank you, Councilwoman Brady.
I would,
Tom and then Councilman
Yep,
Johnson.
through the chair to Mr. Bibb, just a little perspective on this, and in no way am I advocating that we move it forward, but I work for a nonprofit organization that does have executive session, and I think one of the keys to remember whenever you talk about executive session is that, one, somebody has to vote to go into executive session. Two, you cannot make any specific actions or votes within executive session. Those all have to be done publicly, and that's the way our organization operates as well. So we don't often go into executive session, but when we do, it is typically around real estate deals. Oftentimes, we are required to sign confidentiality agreements with parties that we are working with, and those are legal agreements that the private sector works with all the time, right? And so for me to educate my board members on a situation that may be in front of them that they may have to discuss down the road, I can't do it publicly because of a confidentiality agreement we had to sign, and that is the only way I can communicate it with that board. Similarly, we have in the past, I think, mentioned matters of HR that have came up, and again, for legal reasons and for the protection of those individuals, we have to sign all kinds of things of how we're going to handle that. I still have to educate my board on what it is I'm going to do and why, so that they understand that, but understanding that we're all under confidentiality, and therefore those small segments are not in there. Now, however, if there is a vote for our organization to acquire a piece of real estate or do one of those sorts of things, there does have to be, even in our organization, a publicly recorded vote, and those minutes are available. So again, I'm not advocating for executive session, but I think that those are why they are there. It is essentially an ability to educate individuals to what you're doing so that when you come back out, they can make informed decisions publicly in voting.
I understand that
Yep.
completely.
Great. Thank you, Councilman Johnson.
Executive session or other body, therefore for every reason. And as long as I've been here, I've been known us to have to have an executive session. However, I would like for us to be able to do so in case it was necessary. Times have changed, and some of the stuff that we discuss, and some of the stuff that we need to discuss, needs to be done in executive session. Not only other questions, Chairman, if we as a council or we as a committee had to go into executive session, who determines what can be discussed?
Who determines what can, well, the
Probably should
charter,
state it.
the state law, it would be precedent, it would, you don't want to violate it or you get called in front of the,
My point exactly.
so it would be the lawyers,
Sunshine law.
right?
Who would make sure that we would be within the law?
So our staff lawyers or the law department,
Our lawyers, our staff.
yes. Yeah,
Mr. Chair.
There's
Yes,
a lot of case
Councilman.
law.
So this, through the chair to the law director, working off of Councilman Brady's points, are there subject matters in the city government, Homeland Security, things like that, that do not fall under the Freedom of Information Act or Sunshine Laws?
Yes.
And so what would some of those examples be? Like today without this, are there examples of that?
Under the public records law, there are specifically articulated things that there's like two classifications. There's things that we mandatorily cannot disclose. There are things that we may choose not to disclose. And they're articulated in the act. It covers, and then there's a catch-all that says anything prohibited from release by state or federal law. And so common things like a social security number. Now, I don't know that that's something you'd ever be discussing at the table, but there is a section that talks about sensitive security information. I don't have it in front of me right now, but for example, the detailed building plans of the city's ventilation and electrical systems would be a record that we would not have to disclose because it would subject, City Hall to a compromise of the security of City Hall. But there are a large number of things that are exempted from public records. I mean, although like the Sunshine Law for open meetings, the Public Records Law is construed strictly in favor of the person requesting records, and the Sunshine Laws of the state for open meetings are construed strictly in favor of open meetings. So the benefit of the doubt is always given to disclosing public records or having an open meeting.
Okay, so I just wanted to highlight that. So there are already mechanisms and protections in place for
Documents.
documents, right? So if there is a plan from the administration on whatever it might be that's protected under that state or federal laws, what you do not need to disclose, those are protected for the benefit of safety or whatever.
That's right, any records, that's correct.
Okay.
Yeah, and I guess to the viewing public, there have been instances in committees that I've chaired that I've stifled communication. I've stopped conversation because of pending litigation or, specifics to a deployment, what the vice unit is doing today, right? We don't want everybody to know what happens, and that's, and sometimes the administration has said, no, we're not going to talk about that. And then usually it's pending litigation, and when there's a personnel issue in some department, right, and there's an employee and their attorney sitting in the audience, and they're looking to us to garner evidence or something, I say, no, that's not what we're here for. We're here to do the people's work, not one individual's work on a specific issue. Or if the media is running crazy on a specific topic and there's litigation pending, I don't allow the committees that I chair, and the council president's done it as well, to, you're begging for a deposition, really, basically. You're throwing fuel on the fire. And I don't think that has anything to do with open records or sunshine laws. That's just, I don't know, the way to do it.
Mr. Chairman.
But, yes, Councilman.
I'm sorry. But, this enables the entire council to be in one place at one time to be briefed on something that is extraordinary and cannot be discussed in public. Because there are other ways to communicate to the council, which just skirts executive session, whereby we're told we could be told individually, or
You can't be on a matter of public interest. That's still, that's a violation.
Exactly.
Right. So we have to
Exactly.
have
So that's
hearings.
why you have to have, I think, that we have to have a mechanism by which the council can get together and be briefed, and with our attorneys, they would be, I'm sure, advising us as to whether or not that was a pertinent issue to be discussed in executive session. But, many times, it's information that council members really should know before they sit here and they make a public vote.
Okay.
So,
Thank you, Councilwoman. Hearing no further discussion on executive session, I would call the question. No.
okay, no.
No.
Thank you.
No.
Yes?
No.
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 Thank you, everybody. The next one's really quick.
Whatever.
Eliminate the requirement in section 38 of printing at least 1,000 copies of the mayor's estimate. Instead, provide that a sufficient number of copies of the estimate be made available electronically on a city website and to any citizen that asks. And that copies shall be made available in print or electronically to newspapers and public library branches. Discussion? Rachel, quickly?
Right now, and for a long time, there's been this mandate to print 1,000 paper copies of the mayor's estimate, which is a big book about 2 inches thick. It's his budget estimate. I'm not sure that we are in compliance with the charter at this point.
I think everybody's happy to hear that.
Well, yeah, just to get us in compliance, we would like to not have that mandate anymore. We'd like to take that 1,000 copies
It's like 3
out.
of these. I mean, it's huge.
No, much bigger than that, yeah. Oh, 3, yeah.
Yes, just the way it's worded. The way the amendment is worded is the print copies are made available to the newspaper, the public library, and each of its branches. In the prior sentence, it says, shall make available electronically on the website and to citizens who may call for it. I think, and in print to citizens who may call for it. Was that the intention? That, are you going to have a print
Yes,
copy
yes.
available? So I think the words in print should be added between the and the to.
And
that's
in print
two.
to citizens.
Because it,
Thank you.
it's unclear.
Yes,
Chair.
okay.
I would just say that, you know, if a resident or media requests it, that we accommodate whatever format they request it in. So if they don't have access to the internet, we mail it, they can take, I mean, just, I don't know how we write that in there, but just,
Well, I think that would cover it.
Any citizen that asks, and in any format to any citizen that asks.
I don't know any.
well, I guess,
Nothing.
that'd be a term, look at that.
Right?
Read line by line, is that considered a format?
Oh my God.
Orally, I mean, that's,
I say any digital or.
Well, it's, I mean, if you add in print, it says shall make it available electronically on a city website, and you can put electronically and in, or in print to citizen who may ask.
Okay,
Yeah,
that's fine.
electronically or in print to any citizen who may ask.
Call the question. Clerk? Yes.
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 Thank you. Proposal to amend section 39 to provide that the council shall not pass the appropriation ordinance until 7 days after publication or before the first Monday in January. Currently, it reads 15 days. Rachel?
Correct. The appropriation ordinance is the budget ordinance. Right now, the council should not pass the appropriation ordinance until 15 days after its publication. That ends up being about 3 weeks. And it's become, about 4 weeks, it's become kind of, right now with electronic media, things can be reviewed and looked at almost immediately. This original charter section really, what they're doing is they're making sure that the public has a chance to review and understand the budget. And I don't know if they had to like go down to their public library or look at it after it was tacked on the door of City Hall. But now it's a lot easier for the public to get a hold of the budget ordinance.
Right. The
So we
spirit of the
wanted to.
15 days is allowed for public input and
Right.
digestion. The evolution of technology and how we do business, does it really have to sit untouched for 15 days, which in essence is multiple council meetings?
So our
which-
suggestion is 7 days.
So we've said 7 days, which is less than half, but it's still 2 full meetings.
That's what I wanted to point out, just to make sure everybody understands. It's 7 days from its publication. The city record is published 2 days after a council meeting.
Wednesday.
So if you count from Wednesday, this change would mean that you would skip a Monday, assuming
Yes.
that your meeting's held on Monday.
Right.
So if it were, say, discussed on the 2nd of the month, it wouldn't be eligible for vote until the 16th, which gives time. It really moves the schedule up by 1 week.
Right. And again, the appropriations ordinance has just been discussed for 2 months, if not more, in public session on Channel 20, in our neighborhoods. We live and breathe this ordinance for a substantial amount of time, so.
So the public does have ample time as the ordinance is crafted and debated. This is limiting it the time frame from which a vote occurs? Is that correct?
That's correct. And the
Once
ordinance-
the final,
After second reading
Yeah.
of
It
an
cannot be
ordinance,
changed.
it cannot be amended.
gotcha.
And for 15 days today.
Got it.
And the theory is that, so even if there was public outcry and like something about the kennel or something, right? And in that 15 days, we couldn't amend it and then pass it. So
The pie is baked.
the pie is baked and it's an opportunity for the public.
Oh, yeah, and if the public has a problem, what happens, if you amend it, once it's hit the floor, it reverts back to second reading.
Gotcha.
Or-
And
yes,
then we have
right.
another 15 days to comply with state law and get our budget passed. So it looks complicated, but I don't think it really is.
And are current members of council happy with the amount of time that members of the public have to review and provide feedback on the budget? I mean,
Or vote?
yes.
Yeah, I mean, yes, it's printed and provided the first week of February. And we have till
April 1.
April 1 to pass. So during that time, we have full CDBG hearings for a week. We have full budget hearings for 2 weeks. So yeah, okay.
Yeah. And then just, Mr. Chair, just to add on a practical application of that, so the meetings are public, both you can come, you can watch on TV, all that kind of stuff. But what I do, just an example of practical application, I take highlights and talk to my block clubs, talk to residents about it. Obviously, it's a huge document, so I would be screamed out of a block club if I tried to go line by line. But I pull highlights from it.
Okay.
What are the major initiatives? What are the major, line items in the budget? It's just an example of, in addition to the formal public meetings, which is the legal public process, I do take it out as best I can to residents, neighborhoods, people call, talk to them about it, stuff like that. I mean,
Well, and, there's always an issue. Sidewalks, trees, waste collection, all those things that come out of a budget hearing, we talk about every day. And yes, a ton of.
Those that are interested, they know when they're going on. I've watched several of them relating to public safety. I turn them on my computer, watch it, see what's going on, wait for the document to come out and go through it real quick. Those that don't know and don't care, it's not gonna affect them.
Yeah, right, great.
Those that know, and they know when it's coming out.
When it's time to call your council. Hearing no further discussion, I'll call the question. Clerk? Yes.
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 Thank you, Clerk. So there is a packet in for initiative and referendum, Chapter 7. I don't have any specific proposals, right?
There are no proposals from the Board of Elections on that.
From anybody else? I mean, have we received any proposals?
We have not.
Okay. So I'm putting the call to the commission whether or not initiative or referendum petition, if anything jumped out at anybody.
I would just like to ask a question.
Yep.
And it may have been discussed before, since I'm not involved in this body as before this time. On 30, for the council president, has it ever been considered making that an at-large? Or would that be making it too comparable to the mayor? I think it's section 30.
Section 30 of the charter.
I just got it written in my notes. I don't know if
Okay.
I'm looking at it correctly.
Yeah, president of council at the first meeting of May. It's the election of the council president. I mean, and there is an ongoing discussion that we've had, and we've had a couple of meetings, outside of this to talk about elections in the city, and the at-large came up. Staggered elections came up at the very end of, last meeting. Asked people to think about it and contact with any questions. We did have a couple of commission members reach out to talk about it. It is a very overarching, a very big issue and it has dominated. I think what we have decided is to set a date for that, right? To have a full discussion. We want the Board of Elections to provide input. If anybody has that itch, then let me know, and we can sit down and even create a subcommittee, because everybody does it differently, right? There's staggered elections, there's 2-year terms, there's at-large council members, there's ward-based and at-large systems across the country. I think everybody is ultra focused on is having elections matter, having candidates who care, have an opportunity to serve. And is at-large part of that discussion? I don't see why not, right? But, Councilman McCormick. I'm always done.
Thank you, Mr. Chair. No, I think it's very much a worthy exercise in this body to discuss things like at-large seats and how all of that works. If nothing else, just to bring out thoughts and comments from the commission members here, who I think are a solid representation of the community as well. So I think personally it's a worthy discussion to have.
No, and I agree completely. I'm having trouble framing it because I don't know enough